This is Mike Christian. I'm with Empire Management Group. We are a community association management company. We have offices from St. Augustine in the north to Sarasota in the south of Florida, and from the East Coast to the West Coast of Florida. And we are honored to be partnering with Caven Rimbaum for this board uh, HOA uh, certification class. And we would love for you to check us out, learn more about Empire Management Group by visiting our website at empirehoa.com. And over to you, Jeff.
Now turn it over to our lead instructor for today, although Mike will chime in if something comes up that is pertinent to his folks that are might be in attendance today. Let's turn it over now to our lead attorney, our managing partner over in the Orlando Central area of Winter Springs. I got it right this time. I think I always say Winter Haven. Winter Springs, Florida. This is a board certified specialist in condominium and plan development law. There are not many of those in the state. This is Alan Schwartzseid. Alan, take it away, man.
Thank you, Jeff and Mike. Thank you to Mike and to Empire for having us today. Much appreciated. So, for those that don't know me or the firm, K. Bender Rembaum is a law firm that's been in business since the 1990s. We've got, I think it's 24 attorneys as of today, and probably bringing on one or two more in the near future. But in the interim, four offices, including mine in Winter Springs. We've got Pompano Beach, which is basically Fort Lauderdale, Palm Beach Gardens, Tampa, and also this area here in Central Florida. So if there's anything that you need, we've got 8 attorneys, including myself, as Jeff mentioned, who are board certified specialists in representing community associations and condos and HOAs and co-ops. We've got another one who's board certified in construction law. So pretty much anything that your community might need, we've got you covered, and we've probably handled it 20 times or more. As Mike mentioned, if you're happy with who you're working with, feel free to just stay there. I hope you enjoy the class. I hope you get a lot out of it. Feel free to check out our website for all the other free resources that we have to offer. But if you're not satisfied with who you're working with, or you just don't have an attorney, or you just want to explore options, even as a second opinion occasionally, feel free to reach out. My email address is going to be on the screen pretty much the whole time that we're speaking today. But to make it easier, it's as@kbrlegal.com. I'm going to go ahead and share the slides, which, just so you know, don't freak out. You don't have to take notes on every little thing I say today. You will get a copy of these once you fill out your evaluation after the class. Jeff will go through all that information a little later. And hopefully you'll get a lot out of this class today. And, hopefully if you do, you'll reach out. So moving on, because we do have a lot of material to cover. And I'd say not a lot of time. I know 2 hours sounds like a ton. But when you're speaking at the speed that I have to speak to try and get through all this, you'll understand in a minute. So, skipping through information about me, which again, you'll get when you're done. Why the heck are you actually sitting here? Well, if you're a CAM, you just want some credit. If you're on the board of an HOA, well, you need some information. And the Florida legislature says that you must get that information from someone who's accredited to teach a class like this. The directors have 90 days to take this class and get your certificate and put it in the official records. So understand, just taking the class doesn't resolve your statutory obligations here. You need to take the class, get the certificate, which you can get after you fill out your survey, and put it in the official records of your association. That means you're sending that certificate after we're done here today over to either your secretary if you don't have a manager, or to your manager if you have one. Now, this certificate's good for 4 years, so you don't have to take this particular class again for another 3, 4 years after you're done today and you get your certificate. That doesn't mean I don't recommend taking it anyway. There's a lot of information in here. At a minimum, I would recommend you take a legal update class every single year, even though you don't technically get credit for it, because there's a lot of changes that come through the legislature, come in through case law every single year. And if you're not taking that class, or at a minimum following along with our legal updates through Rembaum's Roundup or through our Legal Morsels articles, or someone else's articles, you're probably not going to get that updated information, and you're going to be relying on information that could get your association in trouble. Now, I'm not trying to scare anyone, but I do want to make sure you guys understand, as people taking this class, this is not the end game. Matter of fact, we'll get into later. It's not even the end game for your statutory obligations every year. All right, moving on. As long as you take this class, you are good. But if you don't, it's not that you're off the board, it's that you're suspended from the board. This is automatic after that 90 days from the date that you're appointed to the board or elected to the board. Okay? It's not a board decision whether to suspend that person who hasn't done this or not. It's an automatic, the statute says you're out. Okay? Again, this is a suspension. So there's a big difference between being removed from office permanently and being suspended from office. When you are suspended, the board can fill that vacancy however they want, but as soon as you take this class and get the certificate into the secretary of the association or into your manager, you're back on. So hopefully no one in this room will have to worry about it, and you'll tell your other directors on your board that they need to take this class if they haven't already. Now understand, if you vote and you should have been suspended, but no one on the board bothered to notice that no one has taken this class or no one's certificate is in the official records, any action that you've taken as a director is still good. Okay, it doesn't invalidate anything that the board has done. So the board continues operating as normal unless and until you realize that someone should have taken this class, should have gotten the certificate in, but didn't. Now, the certificate itself needs to stay in the official records for 5 years after the election. So understand, just because you have to take another, and this doesn't make sense to me either, but just because you have to take another class after 4 years doesn't mean you can get rid of the previous certificate. I don't get this at all. They screwed this up in HOAs. They screwed it up in condos. And when I say they, I mean our Florida legislature. But this is the way that it works, and you got to follow it whether it makes sense or not. Okay, continuing education I mentioned a minute ago. This is based on the size of your community. So in addition, and this is directly from the statute, I get this question a lot. If we take our board certification class this year, does that cover this year's four hours, or at least the 2 hours that Alan's giving credit for today? The answer is a resounding, unfortunately, no, it does not. So you will still need this credit that's shown on the slide we have here, in addition to taking this class. We offer these classes on a fairly regular basis. I think we have 2 or 3 that we're going to teach this month. Most of our what we call elective classes offer this type of credit as well. But if you have less than 2,500 lots in your community, you need 4 hours of additional continuing education annually, meaning throughout the course of the year, you got to take 4 classes. A director that has 2,500 or more lots in their community is going to need 8 hours of continuing education. And I guess this makes sense. The legislature thinks that people in huge communities need more education. I don't see how it makes a difference because you're still learning the same topics. So to me, you give the 4 hours or you give the 8 hours, you give it to everyone. Fortunately for everyone that's in a smaller community, and I say smaller as fewer than 2,500 lots, you don't have to do that. Okay, moving on. The purpose of Chapter 720 is to basically say, hey, HOAs are a thing. That's it. Now, it includes a lot more information. And I will say, this is useful information that you should look at later when you're comparing an HOA to a condominium. Okay, the only thing that I will go through, and we'll skip the rest just to save some time because we're not here for a condo class, but an HOA exists regardless of what legislation has been created. HOAs existed way before Chapter 720, which is the HOA Act. Okay, and when I say Chapter 720, that's of the Florida statutes. But HOAs exist based on contract. The contract is the declaration. Okay, a condo declaration is also a contract, but they wouldn't exist if not for the Florida statutes that created and allowed for the creation of condominiums. So that's the big thing that you need to understand. Now we get into which version of Chapter 720 applies. I'm not going to go into detail about Kaufman language, but the thing you need to understand is that without this language that's adopting Chapter 720 as amended from time to time, there are going to be instances where your declaration controls even over the Florida statutes. I would not sit there and try and interpret this yourself. This is something that you need to run by your attorney, but we mention it because it's an important aspect of Florida HOA and condominium law, and because we want you to be aware at a minimum that you need to ask your attorney which one applies. I have a lot of clients and a lot of people that come to me for unofficial guidance that say, well, the statute says this, so it's got to be this, regardless of what's in my declaration, right? No, not necessarily. Okay, if it's a procedural issue, yeah, the statute will apply no matter what the declaration says. What's procedural, what's substantive, we get into in a minute. But when it comes to a substantive law and part of a contract, which is the declaration, like I mentioned, the Florida legislature does not have the constitutional right to override that contract. So, without going into a ton of detail, again, the purpose here is if you're not 100% sure, and by the way, you should almost never be 100% sure, reach out to your attorney because there are a lot of instances within the Florida statutes where it'll say, well, this is the case no matter what, unless your bylaws say otherwise, or unless your declaration says otherwise. And a lot of people will look at that statute and ignore the part that says, unless your governing documents say otherwise, and apply the statute, and they get it wrong. So the bottom line is, if you're not 100% sure, and you almost never should be, if you are 100% sure, even as an attorney half the time, you should probably be taking a closer look. If you're not that 100% sure, reach out to either your manager, who can then reach out to your attorney, or your attorney directly. Now, procedural laws are basically here's how we do things. Substantive laws are this is how you, or this is the right that you have, or the obligation you have. That's the easiest way of describing it. Okay, there are lots of conflicts between Chapter 617, which is the Not-for-Profit Act, and Chapter 720, which is the HOA Act. Now, if someone comes to you in an HOA and starts citing Chapter 718, 719, 721, or 723, you tell them they're an idiot and they need to go away. Maybe you don't use quite that language, but the reality is HOAs are only governed by Chapter 617 and 720 out of these laws. There are other laws such as, I literally just looked at a towing issue under Chapter 715. That Chapter 715 will apply to that issue. But as a general proposition, most of what you're going to look at is going to be in 617 and 720. If there's a conflict, and there are plenty of them between 617, the Not-for-Profit Act, and 720, which is the HOA Act, you're always going to apply 720. Now, keep in mind, this is another, you need to reach out to your attorney. There are a lot of issues that seem to be conflicts if you're just reading the statutes, but when you think about it in depth, you find, well, it's not really a conflict, it's just an alternative way of doing business. Okay, so these are things to keep in mind. Now, if there are conflicts within your governing documents, which, by the way, your developer probably was using a set of governing documents that they've used 150 times already, and their attorney has used 150 times already, which is why it's only 10 grand to get those documents put together instead of 30. Okay. Now, I'm not saying every developer does it this way, but many of them do. Okay. Those documents are revised slightly to account for the way that the association is supposed to be created according to the developer. Then the association amends those governing documents and makes it even more conflicting. Okay, if you don't have an attorney that's looking at the entire set when drafting these amendments, keep in mind they might be creating conflicts that you didn't even think about. When those conflicts show up, if it's within the declaration, you're kind of stuck. If it's within the same document, you have a problem. You got to look at what provision, and your attorney should be telling you what provision controls. But if it's between the governing documents, let's say a provision of the declaration conflicts with a provision of the Articles of Incorporation, the higher document on the list that I'm showing you is always going to prevail and control. So let me go through very briefly what these documents actually are so that you understand. The declaration is what everyone refers to as your CC&Rs, okay? Covenants, conditions, and restrictions. It's your declaration, the document that says, here are the things that govern our community. It's your operational guidelines. It's going to contain all the restrictions, what your assessments are supposed to be, what they're comprised of. Easements might be included so that everyone can do what they need to do. The developer's rights as a declarant to control certain things are going to be in there. Your architectural restrictions. It's most of your day-to-day operation is what you're going to find in the declaration. Then you've got the articles of incorporation. This is basically the document that creates the corporation that runs the association. And I want you all to understand this is maybe the most important thing I can teach you today. When you are running an association, you are running a business. Whether you like it or not, whether you know it or not, you are running most of the time, a not-for-profit corporation. Understand that doesn't make you a charitable organization. Being a not-for-profit in 617 is not the same as being a 501c3 truly charitable organization. So when you're running your business, you need to run it as a business and not just throw out there, well, we need to help the people. We need to help John. Okay, that's called selective enforcement. Okay, so your articles are the document that actually creates this corporation that's going to run the business, going to operate and maintain your community. It might include some powers and duties. Usually those will be found in the declaration and bylaws. Okay, then you've got the bylaws, which is more of your overall manual. Okay, this is where it's going to say what the directors' qualifications are, who the officers can be, whether they need to even be members of the community, whether they need to own property or even live within the community. Okay, so this is the document that basically goes over the top of the declaration, even though the declaration controls. This is the overarching, here's how we run our entire business rather than the day-to-day. And then you've got your board-made rules and regulations and architectural criteria and things of that nature. Okay, so understand this order of operation is set in stone. Your articles aren't going to override your declaration. Okay, it's just not going to happen. Now, the other thing to be aware of, because the board usually has more of an opportunity to amend the lower documents, especially your architectural criteria, your rules and regulations, your, official policies of the association, etc. Those are looked at a lot more closely by a judge, whereas the declaration, unless there's a law that says you can't have this in a declaration, it's going to be presumed that it's valid. Okay? Even things that are completely unreasonable. Think about it this way. I can tell someone, you owe your association $100. We're going to foreclose and take away your home over that $100. Association can do it. That's completely unreasonable. But it's what the declaration says, and it's what the Florida statutes say. So it's allowed. Now, when I say it's unreasonable, what's the alternative? You get a money judgment someone can wipe out in bankruptcy. These are funds the association needs in order to run its business. So when I say it's unreasonable, I mean conceptually, not in practice. Anyway, moving on. Membership meetings. Okay, you've got two types of member meetings in an HOA. One is the annual meeting. That's going to be held once a year. Your bylaws are generally going to say when, where, and how you hold that. Okay, that's another thing that goes into the bylaws is how do you hold your elections? Okay, the election must be held at or in conjunction with the annual meeting, or note the or, not the and, or as provided in the governing documents. So this is another one of those, it's in the statute, you have to hold it in conjunction with the annual meeting, but if your governing documents say otherwise, that's fine too. Okay, this is what I'm talking about when it seems to be a conflict, but it's not. Because the statute specifically says if your governing documents say something else, they will control. Now, the only other type of member meeting that exists is a special members meeting. It's literally any other meeting where the members get to vote. Because that's the only difference between a member meeting and a board meeting, other than the notices that are required. A member meeting, members get to vote. A board meeting, the board gets to vote. Either one is generally going to be run by the board, but the members get to vote at a member meeting. That's it. Now, a special meeting can be called by at least 10% of the voting interests by a written petition, unless a different percentage is stated in the governing documents. What does this mean? If you have 10% of your members that want an issue to be voted on, they can force the issue even though the board doesn't want to touch it. But they do need to get a proper petition in front of the board to have that meeting and have the vote. Every meeting needs an agenda except an annual member meeting. Okay. You don't need an agenda, but I would suggest doing so anyway, because keep in mind, if you've got one of these policies, which this is the first one that I'll recommend that everyone have, and if you don't, there are communities that hire us just to put together their governing documents and set up these policies for them. Okay. The member participation at meetings policy is one that I think, in my opinion, is crucial to make sure that you can operate and do business of the association. Okay. If you have that policy and you have an agenda for each meeting, you can limit that 3 minutes that every member is entitled to only items that are on the agenda instead of an open forum of whatever the heck they want to bring up, including the directors are terrible human beings and blah, blah, blah. Okay. If you want to limit the subject matter of what gets discussed at that meeting so you can actually conduct business, that policy and an agenda are crucial. At a special members meeting, you do need an agenda and a specific statement of the purpose for the meeting. Business conducted at that meeting is limited to the purposes described in the notice. If you have an agenda at an annual member meeting, same deal. If you don't have an agenda, whatever business the board and members decide to conduct technically could be done. Now, all notices, whether it's a member meeting or a board meeting, need to state the time, date, and location of the meeting, right? It makes sense. People want to show up. They need to know what the hell is going on. Where and when and how are we holding this? If the bylaws don't provide for giving notice to the members, again, this is a if the bylaws say otherwise. And I would say if the bylaws provide more notice, and if not, the association needs to send notice of that meeting not less than 14 days in advance of every member meeting. Now, note what this says: mailed, delivered, which is by hand delivery, which I wouldn't recommend because that's a lot of work, unless you have a tiny community, maybe 5 to 6 homes, or electronically transmitted. Now, keep in mind that electronic transmission, we're really talking about email or fax. I don't know of anyone who faxes notices of meetings, but email, if people actually opt in, and that's another form that you should have, is an opt-in to email notices form. If your members have opted in, you can just email almost any notice except those pertaining to a recall. That can be emailed instead of being mailed. That can save your community tons of money when you have just an email list and you click send and it goes out to 1,500 out of your 2,500 members without having to pay for mailing costs. Okay, notices need to be mailed or delivered to the address identified as the owner's address for mailing in the official records. What does this mean? If someone gives you an alternative mailing address, you have to actually use it. You don't just send that notice to the property. Okay, we talked about electronic notices, so we'll skip that. Broadcast notice, candidly, I'm not going to go through because I don't really know of many communities that do it. There's also the requirement to post all of your notices on your association website if you have 100 or more lots. And I have a feeling now that condos are dropping down to 25 units or more as of next year, I have a feeling next year's legislation is going to include reducing this 100 lots or more down to probably 25 as well. So if you don't have a website, you probably need to look into it. If you're using a management firm that actually practices in this area, meaning that they do represent communities on a regular basis, that includes Empire, chances are management has a portal that's operating in place of this website requirement. Okay, so if you're not 100% sure, reach out to your manager, find out whether they're already providing this. If they're not, you might already be too late and you're already 1.5 years out of compliance, or almost 2 years, in fact, now out of compliance. Now, those notices need to go up 14 days before the meeting on the website, just like it's getting mailed or emailed 14 days before the meeting. The only additional requirement is that any contracts or other documents that you're going to vote on during that meeting, if it's a member meeting, need to go up at least 7 days before on the website. You also have to have a separate page that's labeled notices that tells everyone on the front page of the website, here's what we got coming up. Now, I mentioned members have the right to participate. They're 3 minutes. You can adopt reasonable rules and regulations. The meetings need to be held at a location that's accessible to physically handicapped people. If that physically handicapped person who has a right to attend the meeting, not some tenant who has no right to be there, but someone who has a right to be there, asks you to provide a physically accessible place. Now, keep in mind, this is a reasonable accommodation of your rules and regulations. I don't care how you intended to hold the meeting, you may need to provide that physical location. So what I would suggest is yet another policy is a disability related request policy. We have an entirely separate class on this entire subject. It is one of the HOA credits that you can get, but you got to watch it live next time we offer the Fair Housing Act webinar that we have. So that's another one that you might check out if you want more information about this issue. I think there's some more information at the end of the slides, but we'll probably skip it, frankly, due to time constraints. So you might want to check out that class. If you don't need it for credit, you might want to watch it anyway just to get the information. Now, keep in mind, when you have owners that are trying to record the meeting, I know that there are laws that say you can't audio record. There's no reasonable expectation of privacy in a member or board meeting. Members have the right to record these. Your member participation at meetings policy can, however, specifically state that the members don't have the right to interfere with the meeting. So you can say you can't walk up to the board and go like this with their cell phone and start recording in their face. You can say you can't sit there moving your video tripod around the entire meeting to get the best angle. Okay, you set up, you're out of the way, you move on with your life. And if anyone creates a problem within that meeting and interrupts the meeting, the board does have the ability, as part of that policy, potentially also part of a covenant enforcement policy, which is policy number 3, to remove them from the meeting if they're interfering with the ability to hold that meeting. All right. Quorums and decisions, unless in lower numbers provided in the bylaws, 30% of the total voting interests is a quorum, not 30% of those that show up. A quorum is figuring out whether you can even hold a meeting. And that's 30% of the members need to show up unless the bylaws say something else. Okay. A majority of the voting interest present in person or by proxy at that member meeting, where there is a quorum, meaning a majority of that quorum, is generally all you need to succeed on a vote, unless your governing documents say otherwise. So for amendments, a lot of times it'll say you need 2/3 of the entire community. If that's what your governing documents say, you need that 2/3. Proxies must be dated, include the date, time, and place of the meeting. And a proxy, by the way, is just a document that says, John can vote for me. That's it. Okay. Keep in mind, it's only valid for that meeting or any adjournments for up to 90 days. So it's not, a proxy is distinct and different from, let's say, for example, a power of attorney. It's not the same. It's not you permanently have the right to vote on my behalf for any association matters. It's you have the right to vote at this particular election and any adjournments of that election in particular for up to 90 days. Now, if the election's held, it's done, and then you have to hold a subsequent election because there was an error in the election process. That's not the same election. So just understand you're starting over with a new proxy for that type of meeting. All right, and I am going to skip some information. I'm going to cover the things that I think are most important because we have 120 plus slides to get through, and it's already a half hour in. So understand any information that you don't get here, you will get the slides. You're welcome to read through them. And if you have questions afterwards that don't require me to review your governing documents, I do welcome you to reach out. My response might be, however, thanks for reaching out. We would really need a representation agreement to answer that question directly. So you might want to reach out to your current counsel. Anyway, moving on. General versus limited proxies. General proxy says vote however the heck you want. Limited proxy says you can only vote on this issue. You need to vote in this way. Otherwise, it's invalid. Okay. Both can be used to establish a quorum. Doesn't matter what kind it is. Now, electronic voting is a relatively new concept from, I'd say, probably 5 years ago. This is one of those I would suggest looking into it if you're not already doing it. It will save you a ton of time. What it means is essentially that instead of filling in a paper ballot and handing it in at some point during or before the election, people can go online. They don't have to attend the meeting in person, and they can vote online, either on an app on their phone, on a tablet, or on their computer or on a browser. Okay, this makes voting a lot easier. A lot of times, the additional cost is minimal, if nothing, because a lot of these electronic voting vendors are actually allowing you to basically convert the cost of mailing to the cost of what they're doing for you. A lot of them will only charge based on the number of people that actually opt in, and they'll go out and try and get people to opt in if they're doing it the right way, because frankly, that's how they make their money, rather than you having to go door to door to door to try and figure out, okay, well, can we get people to actually opt into this? The other benefit of doing it that way is that a lot of times they'll also opt in when they're opting in to vote electronically. They'll also opt into email notices, which saves the association more money. So just keep in mind, it's not just the ability to vote on an electronic platform that's the benefit here. I think, well, we have an elections webinar. I don't believe we have one that's specific to electronic voting, but we do cover it in a little bit more depth during that elections webinar. The important things to consider are make sure your vendor is actually securing all of this information properly. Most of the ones out there do that. And in an HOA, especially in condos, that 14-day requirement that we put up here doesn't exist anymore as of July 1st. In HOAs, it still does. So you need a board resolution made at a board meeting, noticed at least 14 days before the meeting that you're going to use the electronic notices for. Okay, and it's got to be at least 14 days notice of that board meeting when you adopt electronic voting. The resolution that you're going to adopt is generally going to be provided either by your attorney or by the electronic voting vendor. But I think the practical is a lot more useful than what we've, I'll put it this way, what we're required to put into the slides according to the state. So anyway, these are all just things that the statute requires. Now we get into elections. I used to try and joke and say that this was going to be a long-winded discussion on elections. Follow your governing documents, and that was the end of the discussion. That's the reality. Okay, it's literally just look at your governing documents. 99% of what they say is what you're going to follow. The problem is in condos, you have a specific election procedure for every condo in Florida. In HOAs, it's up in the air. Whatever's in your bylaws, you look at it. If it's conflicting, you just kind of pray that no one challenges it. What I would suggest, if you're considering amendments, consider amending your bylaws so that you're adopting that condo style election process, because it is tried and true. It works. And although it costs money, it's easy to follow because almost every management firm and almost every attorney is capable of telling you exactly what you need to do. Honestly, there are also a lot more articles online that'll walk you through the entire process. Whereas in an HOA, it's literally just look at your bylaws and pray. Okay, so you're not going to have an election unless there's actually a term of one of your directors that's expired. Okay, what would be the point otherwise? So just keep in mind, if you have a director whose term is up, that's when you have an election. If you've got staggered terms, meaning some directors have 3-year terms, some have 2, some have 1, the directors who had 2-year terms are not being elected at the same time as the people that had 1-year terms. Now, the other thing to keep in mind when you're working with staggered terms, please amend your governing documents so that it says what happens when those terms get thrown off by virtue of the fact that you didn't need an election in one particular year. And now you've got, all these people that were supposed to serve 2-year terms that have their terms expiring at the same time as the people that were serving 1-year terms. So that's where I see a lot of people getting caught up when your bylaws don't actually say what you're supposed to do in that circumstance. Because there's no statute that says if you have staggered terms, here's how to fix them after the fact. So at that point, again, it's just kind of ask your attorney and pray. Let's see. A quorum of the members is required, by the way, to have an HOA election. Not required in a condo, but it is required in an HOA. And when we say a plurality of the votes cast by eligible voters, that basically means whoever gets the most votes wins. Eligibility is a major issue as well. So if someone wants to serve on the board, they generally can, as long as they're members of the community, meaning they own a unit or a lot, unless they're otherwise disqualified. What'll disqualify you? If you're delinquent, meaning you owe assessments as of the date that you can last nominate yourself. If you are sitting there saying, oh, well, the governing documents allow nominations from the floor, and we're going to allow that for this election, it's as of the date of the election that you have to be current in your assessments to avoid this problem. If you've been convicted of a felony in Florida or something that would have been a felony if it occurred in Florida, and you haven't had your civil rights restored for at least 5 years, meaning you haven't been out of prison for at least that time, you're not eligible to serve on the board. If you have pending criminal charges for what I'll label as 720, meaning the HOA Act, violations that are criminal in nature, you can't serve on the board. Okay, those are really the main ones. Now, you can nominate yourself or you can have someone else nominate you, but if the election process in the governing document says candidates can be nominated in advance, you don't have to have nominations from the floor. Okay, that doesn't mean you can't do that as well. I know this is confusing. Frankly, it confused me for the first 3 or 4 years I was practicing as well. But the bottom line is this is a can versus must. Okay. Election day, if you don't have enough candidates to actually fill all of the open positions, plus at least one candidate, you don't need an election. If you've got 5 open spots and only 4 people or even 5 people put their names in the ring, so to speak, they put their names in the goblet of fire, okay? You don't need an election because you've only got the amount of people willing to serve that are supposed to serve. Once you get that 6th nomination, now you need an election. Okay, balloting, members have the right to vote in person or by proxy unless the governing documents say otherwise. You can generally put a ballot process in place that uses the condo style where it's inside an envelope, inside another envelope, with the outer envelope being the only one that's marked so that you can remain anonymous. Just really depends, again, how your bylaws are worded. Unless the bylaws say otherwise, like I said, you got staggered terms or potentially just 2-year terms for everyone. Directors serve for a 1-year term and get reelected every single year. Any challenge, and keep in mind, an election challenge is not, I don't like the guy that got elected. An election challenge is you screwed up the process somewhere. That has to be raised within 60 days after the election results are announced, or it's waived, meaning you can no longer bring that challenge. Okay, if we're 6 months into a term and you don't like the outcome, you go and try and get a recall together. We'll talk about recalls later. Okay, the venue is basically binding arbitration with the division, or what I would suggest is filed with the courts. Okay, arbitration is decided by state-appointed arbitrators, some of whom don't have the level of knowledge that people that are supposed to be deciding these issues necessarily have. That doesn't mean a judge has any more knowledge, but I look at it this way from a fiscal perspective. If a judge makes a ruling, you go up to the appeals court. If an arbitrator makes a ruling and you don't like it, you go to a judge, then the appeals court. So my perspective is skip that step, skip the uncertainty of an arbitrator making a ruling that, frankly, over the last 5 to 10 years have been extremely inconsistent and not necessarily in compliance with Florida case law precedent. So it's kind of, it's another, you just kind of pray that they make the right decision rather than going to a judge and knowing I'm just going to appeal it if the wrong legal decision is made. I would always go to a judge or a mediator over an arbitrator if you have the opportunity in an HOA dispute. Now, the officers, the directors are elected by the members. Where a lot of members get it wrong and don't understand, the owners don't get to vote on who the officers are. The directors, the board of directors, get to vote on who the officers are. So I've been using these terms. Let me go through what they mean. Okay, you've got your members. Those are the owners of units, owners of lots within your HOA. Okay. Anyone that owns property in your association is probably a member. Then you've got your directors. This is the board. These are the people that vote on 99% of the issues that get involved in your HOA. Okay, they're the people that have board meetings and vote at those board meetings. They make motions, they second motions, they vote on motions. That's all they do, but it is still one of the most important jobs in the HOA. Then you've got your officers. That's your president, the mouthpiece of the association, the treasurer who's supposed to address all of the funding requirements, including financial reports and things like that. Chances are, if you've got a manager, they're covering that job for you. You've got your secretary who's supposed to keep all the records, sign off on mailing all the documents, sign the affidavits confirming that all of the notices are sent, things of that nature. Again, for the most part, that's going to be handled by your manager if you have one as well. And then you've got the VP who really has no job other than they get to have an officer title. Congratulations. My former partners used to say that's the laziest person in the community, but my perspective is if you're volunteering for a officer or director position, you're definitely not the lazy person in the community. Anyway, fraudulent election voting activities. If I have to explain what this means, you probably shouldn't be on the board. Okay, it's when you try and get a vote to look like something else, whether that's by bribery, forcing someone to vote in a certain way, bribing them, doing, basically changing the ballot so that it shows something else, preventing someone from voting, threatening them to prevent them from voting. Any of this stuff is a first-degree misdemeanor in Florida. Okay, so all of this, I'm not going to go through it in detail. Now, effective last year, July 1st of last year, each of these following acts is also a first-degree misdemeanor. Now, this one is the big one, knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity. And that includes potentially attorneys who do this, which is why if you are asking me to help you get away with this stuff, my answer is hell no, no thank you. I would prefer to avoid possibly losing my law license by giving you guidance of how to get away with a first degree misdemeanor. I am not a criminal attorney. No one in our firm practices criminal law. We're not helping you through crimes. Okay. And here's the kicker. Having knowledge of voter fraud and giving aid to the offender with the intent of avoiding or escaping detection, arrest, trial, or punishment. So bottom line, if you know about this stuff, you got to report it. That's what the statute now says. Vacancies on the board, unless the bylaws say otherwise, can be filled either by a vote of a majority of the remaining directors, even if that's less than a quorum, or by an election. Now, we just went through how complicated an election can be, how easy it is to screw it up, how much prayer is involved in trying to get it right because your bylaws are almost always going to be unclear on at least one aspect of how the election is supposed to work. Why would you take that risk instead of the remaining directors or the sole remaining director saying, Jim's on the board now? Thanks. That's it. All you got to do is set a meeting, put it on the agenda, vote, and move on with your life. So my perspective is you should really never be scheduling a secondary election to fill an empty spot other than at the end of a term. Or if you have a recall and you need to do it. All right, the board. So the officers and directors have a fiduciary responsibility to the owners. This is one of the most important things you'll learn today. Okay, that fiduciary responsibility is essentially you are a trustee of the association. Okay, that fiduciary responsibility, understand, is not to any individual owner, though. It's to the owners, collective, plural. It's to the association in reality. Okay, you need to act reasonably. That is your duty. Now, there's the reasonable business judgment rule. So if you are relying on certain aspects of legal guidance or management told me that this was okay, you might be protected. It's got to be a reasonable business judgment that you're using. If you decide, I had a case a couple of years ago where one of the directors put in an email, she didn't let me do this, so I'm not letting her do it. Okay, but if you're saying you're angry and you should have been allowed to do it, and you know that you should be allowed to do it, you can't stop someone else from doing something on an emotional basis. You can't selectively enforce your governing documents. Okay. That would be a potential breach of fiduciary duty. Now, fortunately, that case settled, but I have a feeling that the judge would have found, if he had pursued to the end, that that was a breach of fiduciary duty to decide not based on what the person thinks is best for the community, but based specifically on what they think is best for them. Okay. No one should be making decisions for the board, by the way, unless that power has been delegated. So your president shouldn't be going door to door without the board saying, please do this, and telling people what their violations are. That gets reported by the association, not the president. Okay. The other thing to keep in mind, directors can't vote by proxy or secret ballot at board meetings except in electing the officers. Every vote of the board is supposed to be open unless you're talking about attorney-client privileged meetings or employee issues of the association. And there's been a flurry of case law regarding that employee issue, so I'll leave that one alone for now. But when you're meeting with counsel to discuss potential or ongoing litigation, that's one of the only circumstances where you can have that closed legal meeting and decide that way. Excuse me. You can use email to communicate. You cannot use email to vote. So if you are going to vote and decide things via email, you better bring it up at the next board meeting and ratify that decision. And you should use that method of deciding things very sparingly. Now, another thing that I'll bring up that wasn't mentioned earlier, if the board is voting via email, the correct way to do that, if the decision is unanimous, would be under Chapter 617. There is a thing called a written unanimous or unanimous written consent. It's basically a resolution of the board that's signed by every single director that says, we all agree on this. The reality is, if you agree on something, and I usually use this as an example, if the board decides we're going to hire K. Bender Rembaum for all our legal needs, the members' input is not really going to change that decision. Okay, and that's the reason for open meetings. The members have the right to give their input. But if it's not going to change anything, and you have to make a decision now because, for example, you've got an issue you need to deal with within the next few days, and it's urgent, okay, there's a pseudo emergency, you've got justification. Instead of holding that board meeting, although it only requires a 48-hour notice and a meeting, but instead of holding that meeting, you're going to sign this unanimous written consent. That replaces the board meeting under Florida law. So again, use it sparingly, but it is an option. Notices, again, 48 hours notice of most board meetings just posted within the community. That's all that's required. However, unless the bylaws say otherwise, you need a 14-day notice if you're adopting a special assessment or you're changing rules regarding use of the lots. Now, keep in mind that 14-day notice regarding use of the lots. That doesn't mean that every policy you adopt needs that notice. If you're amending your policy governing use of common areas, that's not use of the lots. You can use a 48-hour notice on that one. But again, I would run some of these by counsel. Again, 48 hours notice except in an emergency. I have never in practice seen a real emergency that wasn't based on some kind of storm, illness, or something similar. But I'm sure they do pop up outside of those circumstances. For example, you've got a pipe burst, you need to hold a meeting and make a decision to take care of it. Yeah, go ahead and do that. Again, notice goes on the association website. This one is 48 hours before, unlike the member meeting, which is 14 days before. And it's 48 hours before to post the documents you're going to vote on, just like it would be 7 days to post for a member meeting. So board meeting is 48 hours, 48 hours, 48 hours, unless it pertains to assessments or it pertains to changing use regulations. All right. Again, we talked about websites. Member participation at board meetings is exactly the same as member meetings. You can have your policy. The only distinction is members don't get to vote at board meetings. They get to say their piece. The board can completely ignore them if you want to. That's not the best idea, but you do not have to do what even a majority of the members in attendance tell you they want you to do. Recording and handicapped access, same as at a member meeting. Compensation. There is no compensation for directors or officers of an HOA or committee members, except participation in financial benefits that everyone gets, reimbursement for out-of-pocket expenses that are real HOA expenses, recovery of insurance proceeds that everyone else gets or that's pertinent to your specific lot, fees or compensation authorized in the governing documents or vote a majority of the voting interests. So understand you can be compensated, but only if the members say you can. Or a developer representative that's serving in this capacity can be paid for that service because these are professional board members. Kickbacks. The most detail I need to provide, I hope, is you're not allowed to accept things that not everyone in your community is getting for free, or solicit or offer to accept any of these things that have any value. Anyone that does this, it's a third-degree felony, subject to monetary damages. You're also immediately removed from office if you accept kickbacks. The only exceptions are food to be consumed at a business meeting with value of less than 25 per person. This is why I can't take you to Ruth's Chris if you are a board member and we want to do business together.
Not even with a coupon?
That'd
Sorry.
have to be a pretty big coupon. Or services or goods received in connection with trade fairs or educational programs. So if you go to the CAI trade show that I serve on the board of for Central Florida, if you go to the condo and HOA expo that I'll be at next week teaching 2 classes, all those types of things are trade fairs and education programs. Okay, this class is an education program. If we did this in person and we gave you some, pens, pads, stress balls, etc., that's all okay. As long as we're not giving each one of you a new TV, we're good. All right. We talked about grounds for immediate removal. Some of the additional ones: forgery of ballot envelopes, theft or embezzlement of association funds or property, tampering with physical evidence, meaning you're trying to avoid the official records showing the cops that you did something you should not do. That is also a crime. Obstruction of justice, which is similar, or any criminal violation under the HOA Act. You are immediately removed. Now, you do come back on if you are found not guilty or the charges are dropped, if your term has not already expired. So this is kind of a suspension, but it's an actual removal. The board must fill the vacancy until the end of the period or the suspension. And that's pretty much it. The other thing to keep in mind is if a criminal charge is pending, the person can't be appointed or elected to a position as an officer or director of any association and can't have access to the official records of any association except by court order. So that's the only exception to the owners being entitled to inspect and copy your official records, is if they were removed for one of these criminal acts. Anyone who becomes more than 90 days delinquent is treated as having abandoned their seat. They're off the board. This is another one of those doesn't require a member vote or a board vote to say this person's off. It's automatic. Once you're 90 days delinquent, if you're on the board, you're not on the board anymore. That is not a suspension. It's a removal. Okay. Conflicts of interest, I'm going to go through very briefly. At least 14 days before the board's going to vote on an issue, you need to disclose that you have a relationship with the vendor that's going to serve in that purpose. Okay, this is for proposed contracts, proposed services. There is a rebuttable presumption that there is a conflict, meaning that you can challenge that presumption in court, but the burden of proof is going to shift to the person with the alleged conflict if any of these things happen without prior disclosure to the association. This is the director or officer or one of their relatives entering into a contract with the association, or holding an interest in a corporation or other business entity that proposes to do business with the association. So this is up to what we call the third degree of consanguinity. That's a legal term that basically means if you're a grandparent, grandchild, or cousin out to, I think, the second degree, or a brother, sister, etc. Any of those family relationships are going to be subject to this law if they're proposing to do business with the association. Again, you disclose at least 14 days before the voting. Okay. The board also needs to have a vote of at least 2/3 of the other directors present. Now, keep in mind, this director will still count for a quorum, but they can't vote. They can't participate in the discussion of the board, but they can present the contract and then leave the room. If it isn't disclosed, then at the next regular or special member meeting, the contract with the director needs to be disclosed and the contract can be canceled by a majority vote of the members present at the meeting, meaning that that contract gets terminated because there was no disclosure and the only obligations of the association are to pay up through the date of that termination. All right, moving on to official records and moving on to, I think, my first sip of water for the day. So we're going to skip some of this, and here's why. The official records of the association are, we'll skip to this last bullet here, all written records that are not specifically identified related to the operation of the association. What does this mean? Anything that's written and pertains to association operations is an official record. Okay? There's a whole list here of what you need to maintain, how long you need to maintain it. This is yet another set of 2 policies that I recommend everyone have. One is statutorily required. So number 4 is going to be a records retention policy. This is how you're going to keep your records, how long you're going to keep them, what goes on the website and what doesn't, if you have one, regardless of whether you're required to, when are documents going to be deleted, trashed, or however you're destroying them. Okay. All of that goes in this policy that I think everyone should have because the statute says so. Okay. You're going to keep everything for 7 years except for the statute that says otherwise. One of the statutes that says otherwise is that bids are to be kept for 1 year. Okay. The other thing that's kept for 1 year is election related records. All those are kept for 1 year. And I already talked about this new requirement that was effective last year. Now, all your official records are subject to inspection and copying by the members. But there's a whole list of items that are actually not subject to that inspection. So there's a difference between what is an official record and what is subject to inspection. The official records that aren't accessible to the members, whatever's protected by attorney-client or work product privilege. Now, I want to be clear, that attorney-client privilege is not something that the president gets to say, I'm going to send out this attorney-client privileged email that has all of our strategy for the rest of our case or a case that's even closed without getting a board vote on that issue. The attorney doesn't have the discretion, doesn't have the authority to say, well, I'm going to breach that privilege. I'm going to testify in court as to what was discussed. Okay, that's something that stays with the board. Now, that's the board in any iteration. So it could be the board 3 years from now, none of whom were actually part of that conversation, but all of whom have a copy of it that chooses to disclose that information or chooses not to. Okay, but it's not just an individual. Other information that the members don't get to access is information received in connection with a lease sale or other transfer of a parcel. A lot of the time, this is going to be your, ESA request and things of that nature. It's also going to be your background checks and things like that. The members don't get access to that information, even the person whose lot is being leased or sold. So understand, just because it's, oh, well, it's my lot, I'm entitled to that information. Sorry, but no, you're not. Information obtained at your guard gate, social security numbers, and other personal information other than the person's name, lot number, mailing address, and property address. Okay, now if you give away some of this information, it's kind of a no harm, no foul. If the association didn't do it on purpose, okay, you're probably all right. Personnel records, medical records, electronic security measures that are used by the association. So that's your passwords, your login credentials, things of that nature. Obviously, you don't want to give away that information. There's a reason those credentials exist and are for the association alone. Okay, you don't want everyone in the world or everyone even that's an owner in your community to have access to all of your systems to be able to modify your records, etc. And along those lines, the association software and operating system that allows for manipulation of data. So what does this mean? You're going to give away your, what's it called? QuickBooks reports, but you're not going to give direct access to the QuickBooks software. Okay. And then affirmative acknowledgments made with respect to collection of assessments. Talked about attorney-client privilege. You can have a roster, a member directory containing the name, lot address, and phone number of each owner. People can ask to be excluded. The association does need to comply with that request, but that request needs to be made in writing. The owner can also provide written consent to disclose additional information in that member directory. This is not something you need to have. All you have to have is a roster. Okay, but this is a separate, like a phone book just for the association, whether it's in PDF form, which is the way most people do it now, or Excel or some other format. Hopefully everyone's complied with this because it's been over a year since you had to comply with it. But this is basically saying all your rules, your covenants, your declaration, your governing documents, you need to provide a copy of the documents themselves or notice that it's available by October of last year, 2024. So hopefully next year we can take this out because at this point, if you haven't complied, I don't know what to tell you. Access to official records. So I said everyone is entitled, that is an owner in your community, to inspect and copy your official records. This is policy number 5. How are we going to do this? How frequently can you make the request? Where are the requests supposed to be sent? What method are they supposed to be sent? Are you going to accept emails or does it have to be sent by certified mail, return receipt request, like the statute requires in order for a presumption to arise that it was received and should be responded to? Excuse me. Okay. Now the inspection needs to be offered, not that you send a response, but that you actually provide the inspection within 10 business days after you receive the request in writing and within 45 miles of the community or within the county. So the association can just have these records available on print or on a computer or just email them out. Or frankly, my perspective is if you put everything in your member portal or on your website, you can just say everything's available. If there's anything you can't access, or if you prefer not to access it that way, which is the way people get in trouble by not saying if you prefer not to do it that way, let us know and we'll make it available to you in the normal fashion. Now, again, the important part here is you're not sending an email on business day 10 saying, hey, you can come in and inspect the records next week. You're sending an email or a letter or responding the way that your policy says you will, so that the date of the inspection is on or before that 10th business day. Okay. If the request is submitted by certified mail, return receipt requested, and you don't timely provide those records for inspection and copying, there is a statutory presumption, again, a rebuttable one, that you can say, well, no, we didn't have the records because there was a hurricane. Things like that. Okay. It is rebuttable, but the court will presume that the association's failure to comply with that timeline was intentional and that you're just holding back the records. That doesn't mean the court presumes that you have something to hide. It just presumes that you're ignoring the request and that the owner's entitled to what I call the $500 gift. Okay, that $500 gift is $50 per day up to 10 days, starting on the 11th business day after receipt of the written request. So you can have up to $500 as a fine, as well as any attorney's fees and costs that that owner incurs in defending or trying to get those records from you. If an association receives a subpoena from law enforcement, you have 5 business days or however long they provide you to produce those records. I don't know of anyone that was refusing to provide records to law enforcement, but my guess is there was someone in 2023 down in South Florida that refused. And, as a result of one incident, we now have new laws. Which, by the way, in case you don't know how the sausage is made, 75% of the laws that come about in condo associations, from my experience, are the result of one bad incident. Anyway, official records crimes we already talked about, but basically anyone that is failing to produce these records, this is the important one, 2 or more violations in a 12-month period is now a second-degree misdemeanor. So that's a director or manager. Now, I don't know how a director can control a records inspection other than directing the manager to say, don't provide this. Now, the manager should also be aware of what the statute requires and comply with these timelines rather than knowingly, willfully, and repeatedly failing to provide. Where I see this coming up is owners misunderstanding what they're entitled to. We talked about a bunch of exceptions earlier. Okay, those are the exceptions where you don't have to provide these documents. And I literally, over the last week, have gotten 3 separate records inspection requests. And all they asked for was copies of all correspondence between association board members and the law firm representing the association pertaining to this issue. None of that is subject to production, buddy. Sorry, but no. So the response is there are no records that would be responsive that are not subject to the attorney-client privilege and that we won't be producing anything. We do have people that are adamant that they're entitled to see that information, even though they're wrong. They report to the police reach out to the association, and the association's response is, yeah, we don't have to provide that. I didn't willfully fail to comply. I'm protecting my association, which is my legal right to do. So I would run those by counsel, but understand that it's not every single record that the owners have a right to see. Again, you can adopt reasonable rules, but what you can't do is require an owner to actually show proper purpose for the inspection, state a reason for the inspection at all, or limit the inspection to less than 1 8-hour business day per month. What you can do, however, I haven't seen a ruling by an arbitrator yet that says you can't do this, but you can limit it to a 2 hour per day, and we will reschedule and you can come back tomorrow for another 2 hours, up to that 8 hours per month. If someone chooses to make a copy on their own device, so they use a cell phone, tablet, camera, whatever it is, you don't charge for copies. If they're not using their own device and they need copies and you have a copier, you can charge up to 25 cents per page for all copies above 25 pages. First 25 pages are free. Okay, if you need a vendor to do this because it's 1,000 pages that they want copied, you can show a vendor invoice or my opinion is a vendor estimate of what this will cost. Show it to them and say, we need payment up front. Otherwise, we're not spending this money to make the copies that you're not going to pay for. Okay. Same thing with personnel costs. You can charge up to $20 per hour, but if it's copying less than 25 pages or inspecting less than 25 pages, and there's nothing that you need to retrieve from somewhere else, okay, if it's less than a half hour to retrieve from somewhere else, you can't charge. But again, up to $20 per hour, and that needs to be supported by either a resolution of the board or your management agreement. Now, keep in mind, this is personnel costs. It needs to be something that you would actually be paying the person for, and you generally wouldn't be paying the board to do this work. This is a volunteer position, unless your governing documents say otherwise or your members have voted otherwise. So generally speaking, this is if you have the manager actually producing the records. We talked about websites briefly. By January 1st of this year, if you have 100 or more lots, you're supposed to have the website. It needs to have username and password credentials for each members. We have a list of documents that need to be posted. I'm not going to go through them in detail, but understand there is a difference between what needs to be on the website and what should be on the website. Not all documents that are subject to inspection and that are official records need to be on your website, even though that's still my recommendation just to make it easier for inspection purposes. Documents that are not subject to inspection are not to be posted on the website. Now, they can still be on the portal behind board-only login credentials. Anything that is protected, where you're supposed to put the document up, but it has, let's say, a social security number on it or something like that, you do have the legal obligation to redact that document and remove that social security number before you post the document. However, again, it's a no harm, no foul. If you don't do this on purpose, it needs to be with a knowing or intentional disregard of the protection. No harm, no foul. You're probably not going to be liable for it. Amendments. We've got an entire class on this one as well, and I do believe it is, yeah, it's for HOA credit as well. So if you want that 1 hour, you might want to check out that class next time we present it. But the bottom line is, unless your governing documents say otherwise, the statute says you need 2/3 of the voting interest of the association to vote on amendments. By the way, one of the most popular amendments that we do is an amendment to reduce this voting threshold to, let's say, a majority of a quorum. Okay, make it easier to take care of this. The format is supposed to be where you underline new text, strike out deleted text, but if you're making major shifts and major changes, and that would actually be more confusing than just restating the new text, you can just do that, but you need to include this statement: substantial rewording, see governing documents for current text. Okay, if you have a provision, and this is more for your attorney, but if you have a provision that says that the lenders on all of your lots need to approve all amendments, the Florida statutes say they generally won't anymore. So if you've been holding back on attempting amendments because you're afraid you won't get that lender approval, understand that you really just need to give 60 days notice to the lenders. We call it negative notice. It's basically you have 60 days to challenge this amendment. Otherwise, we're going to presume you're good with it. Now, keep in mind, you also now only need to give that consent or ask for that consent, that negative notice, when that amendment is actually going to impact the lender's rights. So a lot of amendments will have no impact whatsoever on lenders. So those you don't even need to send that negative notice. You just go through and get your member vote and move on with your life. Now, one thing that I see fairly frequently that can hold up the amendment process and frankly cost the association a lot more is the board attempting to do this themselves. You've got your amendment committee or your governing document committee that spends hours and hours and hours poring over the language. And then we find that, well, you just created a conflict with another provision of the governing documents, or you wrote it in a way that no one's going to understand because you're not a lawyer, but you tried to write it in legalese. My strong suggestion is make a bullet point list of all the things you want changed from a basic point of view and get that list to your attorney so they can draft these amendments because they're going to probably have done it 1,000 times, whereas this might be the first time you're attempting it. Think about, a first-year associate trying to write an entire amended and restated declaration with no legal experience, or at least none in this field. Why would you think that you'd be any more successful than that first year associate? So my perspective, if you're going to do these massive amendments and it's more than just one or two, pardon me, provisions that you're trying to change, get your attorney to draft the whole thing. Now, these amendments are effective as of the date that they're recorded in the county records. So it's not just, well, we had the vote, we signed the certificate, now it's effective. No, not till it's recorded. Now, the copies, within 30 days after recording the amendment, the association needs to provide a copy. Or if you provided a copy in advance, which is, from my perspective, the best way to do it so that people know what they're voting on, then you can just provide a quick, business card or postcard that says, here's the recording information for the amendment you voted on. Okay, we'll talk about some of these later. Government filings. You do have an obligation to keep up to date with this Florida Division of Corporations. You also probably have an annual income tax that needs to be filed. Just because you're a not-for-profit doesn't mean you don't need to file a tax return. I do see some communities getting in trouble for not realizing this. Okay, you do need to file every year. What I also see coming up is people concerned that they're going to lose their not-for-profit status because they end up with money left in their accounts at the end of the year. I can't give tax advice, but my understanding from reading about 150 articles on this topic and speaking to a couple CPAs is that, and speak with your CPA if you're debating this, but you need to have some money left over at the end of the year to pay January's expenses. What this results in is generally going to be a little bit of taxable income. Okay, it doesn't change your not-for-profit status. You don't suddenly shift to a for-profit entity just because you've got some cash left over at the end of the year. So that's not something you need to worry about. Meeting minutes, all meetings, including closed meetings, need minutes taken. They don't need to be and should not be a record of everything that was discussed or everyone who made a comment. Okay, when you put in there, John said this, then Jane said that, and John disagreed, and here's the complaint that this owner raised, all you're doing is setting up their claim when they decide to sue the association. Let them prove that this is what was discussed or that the board disregarded it according to them. The only things that need to go in your meeting minutes, only things. What was the motion that was made? Who made it? Who seconded the motion? How did every director vote? Who abstained because they had an actual conflict? Okay, and abstaining should never be done just because you don't like the options that the board is giving you. You vote. That's your obligation as a director. Okay. But those are the only things that need to go in or should go in your meeting minutes. What was the vote? How did it go? That's it. Okay. It can be literally 2 lines for each motion. And if you only have one motion, you can have minutes that are literally, here's what's on the agenda. We followed the agenda. We went, we had this one motion. It passed. That's it. Now, understand when I say it passed, that means recording the vote of each board member. So that is something that needs to be done. All right, material alterations. We're moving on a little bit, and this is kind of a jumble of issues that don't fit in anywhere else. So understand, I apologize if we're kind of jumping around here, but that's a big part of the reason. Material alteration means you're basically changing the way that your building looks or changing the way a common area looks. In an HOA, generally you don't need membership approval for material alterations, but you do if the governing documents say so in some instances. And you might have a provision that says, well, you need member approval if you're going to spend X amount of dollars on any improvements within the community. So those are the two things to look out for. It's not going to be in the statutes, it's going to be in your documents. It might not be anywhere. And if you don't have it anywhere, you don't have to have that vote. The other thing to keep in mind is that if you're talking about implementing more protective measures, and I don't recall offhand whether this is in, no, it's not, so I'll mention it anyway. I didn't remember whether it was in the slides. If you're implementing something that is more protective, for example, you have your paint on a building, the clubhouse, for example, and you're going to replace that paint. You're going to paint over or do whatever you want to do. And the paint that you had wasn't really protective at all. It was just flat paint. And you're going to put some waterproofing on, waterproof paint, etc. You're making sure that your building envelope is a lot more secure. That's more protective. It probably doesn't require a member vote, even though the governing documents say you should get one. Now, we get into rules and regulations. Okay. You can have rules on pretty much anything you want other than discriminatory rules. However, they need to be supported by your governing documents to be valid. Okay, in order to be effective and valid, a rule needs to be supported by the governing documents. It can't contradict anything that's in the governing documents, and it needs to be reasonable. Those are the 3 criteria. Okay. These are generally adopted by the board, but I literally ran across one last week that required member approval of 50% of the members to adopt any new rules or changes to rules. I think that's absurd because at that point, why not just say we can't have rules? It has to be an amendment to the declaration. That's basically what you're saying. But understand, like I mentioned earlier, you got your 14 days before the meeting if you're changing the way that you use your parcels. That's going to be all of your architectural criteria. It's going to be what you can and can't do on a lot, what you can and can't host on a lot, including improvements on a lot. And then if it's governing any other aspect of the community that isn't the lots themselves, it's a 48-hour notice. Marketable Record Title Act, I think we should have a class on that in and of itself. It's actually on my list to create one. But essentially, this is the law that says if you don't preserve your covenants 30 years after what's called a root of title, those covenants expire. We've got a couple communities that recently, over the last 6 months, I think there's been 4 or 5, that we've actually had to revitalize, meaning revive their covenants because they expired and became ineffective, meaning you couldn't enforce them anymore throughout the state of Florida. Now, you can avoid this by doing what's called a preservation. So the first thing that we do when any new client comes in is we order the governing documents. We make sure that they're all compiled, OCR'd, bookmarked in one PDF. We send them out to the client. And on page 1 of that document is a table of contents that says, this is the name of the community, this is where it's located, here's our client number so that the clients have it, and here's the date for HOAs that the covenants will expire under the Marketable Record Title Act. That's step 1. That's how important this is. The first thing you see, other than your community name and location, is here's how long you have before this expires. So if you haven't done a preservation, it's 30 years. Now, a lot of people say, like we do in the slide, it's after the initial recording of the declaration. In reality, it's 30 years from the date that each lot was sold to an end user. But that analysis is so cumbersome, especially since some of the communities that you guys are in might be 10,000 lots. To do that evaluation for every single lot is such a pain that we just go by the date of the declaration. And the reason for that, and something that I missed earlier, that I usually cover earlier in this class, the declaration is necessarily recorded before any of the deeds to any of the lots in your community. Okay, your covenants need to be created first so that they actually encumber, meaning they burden every lot in the community. So the developer will usually just say, this entire area is covered by the declaration. You might have a legal description by meets and bounds in your declaration as an exhibit. It might just refer to the entire plat for your community, but you're going to have a physical description of what this declaration covers. If you don't, by the way, that's a major issue that you need to run by counsel. But if that description is there, it includes all of the eventually platted lots. That's also why all of the deeds to the community, every single lot's deed, is actually inferior to the declaration. Because in Florida, first in time is first in right. So the declaration was recorded first, like I said a minute ago, which means that the deed being recorded second is an inferior title document. So that's why everyone is subject to the declaration, even though, yes, absolutely, this is my lot. Good for you. You still need to follow what this declaration says because you are on what's called record title notice, constructive notice, meaning this document, this declaration was recorded in the county records before you bought your lot. You should have looked, not that anyone does, but your due diligence as part of your purchase of that lot includes looking into these issues. And if you chose not to perform that due diligence, that's not on me as a board member. That's on you as the purchaser. All right, jump off my soapbox for a minute here. The covenants can be preserved for another 30 years, basically by recording a document that outlines and names by recording information all of the documents that you want to preserve. This is something we do for a lot of clients. I have a policy where 3 years before those covenants are going to expire, according to either the date of the last preservation or the date that the declaration was recorded, I send a letter out to the client saying, hey, here's what this entails. Just understand you've got 3 years left to take care of this. If you don't, there are major consequences, and here's what they could be. And then hopefully the client responds right away and says, oh, okay, well, we'll keep that in mind. We don't need to do it next year because you told us you don't need to do it this year. We probably don't need to do it the following year, but right after that, we really need to take care of this. So 2 years from now is probably when we'll take care of it. Okay, great. I'll follow up every 6 months. There will be no charge unless you ask me for guidance. Okay, that's the way that I operate. I can't speak for any other law firm, but I want to make sure that my clients don't have issues with this stuff because it really does mean that that person that's wanted a pink house with purple polka dots for the last 15 years that they own their lot, all of a sudden, your architectural restrictions no longer apply because your covenant's expired. They can put that pink house with purple polka dots within your community, and you can't do anything about it until those covenants are revitalized. And even at that point, they might be, and I don't like the term grandfathered, but it might be a violation that you have to permit to remain in your community, at least until they're going to repaint that residence or they need to repaint. All right, moving on. Emergency powers, I'm going to skip through, but understand you do have special powers if a state of emergency is declared in the area that the association's in, whether that's your city, your county, the state, or the entire country or the world. Okay. And this is if there is potential damage or injury that might be caused by the item that caused the state of emergency. The reality is, this is hurricanes, tornadoes, which we do get in certain areas of Florida, including here in Winter Springs. Not that I've actually seen one in person, but I know that it happens. Or because of COVID, we now have injury or damage. Okay. It could be illness. But if there's a state of emergency declared, that's what's required. It's not just you have some crazy things going on in your community. And so you're going to take advantage of all these provisions. It's not a community-wide issue. Okay. It's a municipal or a government adoption of that state of emergency. And it lasts, those powers last until the state of emergency is over. So, for example, you have the right to adopt certain special assessments without a vote of the members, even if your governing documents say that a vote of the members is required. I actually was able to use the fact that one of these special assessments was passed during COVID under these emergency powers as a way of validating a special assessment that the association really needed, but didn't do the right way. Okay, so understand again, only if the state of emergency is declared and only for as long as the state of emergency is declared do you have these emergency powers. Debit cards. Bottom line, don't use a debit card in the name of the association and you won't have this issue. Use a credit card. Done. Game over. Legislature doesn't care about that. Okay, but debit cards, because the funds come directly from the association account, it is actually a crime to use a debit card issued in the name of the association or billed directly to the association for any expense that isn't directly listed in the budget or adopted by board vote and resolution in advance, with the meeting minutes actually having been adopted. So bottom line, use a credit card, pay cash, get reimbursed. Just don't use debit cards that are paid directly by the association or issued to the association to spend any money ever. That's it. Litigation authority. Now, this is one that people get wrong very frequently. Before you file a lawsuit in the name of the association involving amounts in controversy exceeding $100,000, you need a vote of a majority of all the voting interests at a meeting of the members where a quorum's been attained. What this doesn't say is if you sue for 50 grand and spend 55 grand in attorney's fees, you're supposed to go back and get a vote of the members. Okay. It's $100,000 in controversy. That's your damages. If it's less than that, you do not need this vote. If it is in excess and you didn't get the vote, okay, you screwed up. You should have gotten that vote. You failed to do it. You filed that lawsuit. You know, your attorney didn't tell you that you were supposed to do this. Okay, well, you go back and get the vote and then you move on. Okay, usually if someone raises the fact that you didn't get this vote, this is intended as a shield, not a sword. Okay, so it's not intended for your members, or more importantly, people that are not even members of your community that you sue because, let's say, a vendor causes a problem, you have a construction defect, or you had, construction work done that was shoddy, whatever it may be. That's not what the statute was intended for, to protect those people from lawsuits. It's intended to protect the association from getting itself involved in major lawsuits that it shouldn't be involved in when you're suing the members or suing anyone. So again, that vendor raises this issue in court. The court should say, I'm staying this case, meaning I'm putting it on hold pending the outcome of that member vote. The association goes back, does what it needs to do, gets the member vote, gets enough people to say yes. You bring that, report back to court where the members had the vote, the meeting minutes are here, blah, blah, blah. The judge says, okay, case can move forward again. That's it. Bottom line, don't forget to do it. Remember that if it's an excess of $100,000 in damages, you need that member vote. And other than that, just go about your daily life. Architectural control. So effective July 1st, 2024, this is the start of the truly stupid laws that the legislature has put in place. Oh, I'm sorry, this isn't it, but this is annoying. I was thinking it was a different one that we'll get to later. You do need to reasonably and equity apply and enforce all of the architectural improvement standards or other published guidelines. That's just basically saying no selective enforcement. That I'm fine with. You already weren't supposed to do selective enforcement, which that's why there's case law that says you can't do it from the 1970s. This is not a new concept. It's just being codified in the Florida statutes. Now, if the association denies an architectural application, this is the one. Listen, I don't love it, but I think it makes sense. When you deny an architectural application, you have to actually say, here is the provision of the governing documents that we're relying on, or the provision of the architectural standards we're relying on to say that we're allowed to deny your application. Okay, so you're identifying Article 5, Section 3 of the Declaration says that you can't have a satellite dish, which is a bad example because there's separate laws on that, but you can't have a shed that's the size of your house in your backyard. Okay, can't have sheds at all. Can't do it. Now, in Central Florida, that's like a no-no. Everyone has a shed, but there are communities that have governing documents that say you can. Okay. So if your governing documents say you can't have a shed and someone applies, you deny. Yeah, it makes sense that you denied, but you have to tell them why now. That's the thing that changed on July 1st, 2024. This is the one that I was trying to say is ridiculous. Okay, you can't enforce a covenant, rule, or guideline that limits or places requirements on the interior of a structure that you can't see. So, okay, well, they can have meth labs other than the fact that it's a crime. A meth lab inside of a lot is totally acceptable now, and all I can do is report that to the police. That's what you should have been doing anyway, and it's a little bit of an absurd example on purpose, but that's basically what this legislature is saying. You have zero control over that now.
Even if Heisenberg is your neighbor.
Well, I mean, if Heisenberg's your neighbor, I would move anyway, because there's just a lot of stuff going on that I don't want to live in that house,
He is the one who
especially with the
knocks.
pizza on it at the end of the series. But anyway, anything that requires the review and approval of plans and specs for central AC, refrigeration, heating, or ventilation systems, if it's not visible from the frontage, adjacent parcels, adjacent common areas, or a community golf course, and is substantially similar to anything approved or recommended by the association, you can't require approval anymore. It's not that you can't say you can't have this, it's that you can't even bother to require the approval. Here's another stupid one. Okay. And I say that in all candor. I just think this makes no sense. What is the point of having covenants if you're not allowed to enforce them anymore? If it's not visible from the frontage, meaning the front of the lot facing the front door, it's not visible from an adjacent parcel, adjacent common area, or a community golf course, you can't tell someone they can't have it. Now, they've explicitly included artificial turf. So you're telling me someone can completely screw up the drainage. And if I can't see it, I have to wait until they flood their neighbor's lot or a common area to actually tell them it's a violation. This makes no sense. Okay. Again, it's also well, you can have something that's dangerous in your backyard, and if we can't see it, we can't control it. But we know it's there because we're hearing the chickens clucking all day long. There's just a lot that makes no sense here. The other thing they didn't cover is, what if I can see it from across a lake? That's not an adjacent common area. Okay, it might be, but it's not necessarily. It's certainly not an adjacent parcel that I can see it across the lake, because the adjacent thing is the lake. Okay, it has to be a community golf course. What if I can see it from a golf course that's not owned and operated by the community, but is directly adjacent, that is connected to the community, but is run by a completely separate entity and is not exclusive to membership within the community? So these are just things that the legislature sometimes doesn't think of, or thinks of and frankly doesn't care enough to correct these things before we have to deal with it as a law. Now, the good news here is, I mentioned earlier, you've got your constitutional issue run by your attorney before you just unilaterally decide, oh, well, this law says we can't do this anymore, so we're not going to do it. It's unconstitutional for the legislature to tell you the covenants that might have been in place since the 1960s are suddenly not enforceable. Now, if it's discrimination, that's a different story. I've literally had to remove provisions that said no blacks or Jews may reside in our community. I was proud to remove it, That's not enforceable, but keep in mind, that's pretty much the only type of circumstance that you will have that statute overriding what's in your existing declaration. So just something to keep in mind. Hurricane protection policy number 6 that you are now required to have this one is basically what are you going to allow and not allow, and when is it allowed to go up, come down, etc., with respect to hurricane protection in your HOA. These are more vehicle restrictions, the restrictions that you can no longer address, even though they've been in your declaration for 70 years. You can't prohibit parking a personal vehicle, including, pardon me, a pickup truck in the driveway, even though you have pickup truck prohibitions in your governing documents. A work vehicle, regardless of the official branding that's on here, unless it's a commercial motor vehicle, which is like not even a semi sometimes qualifies as a commercial motor vehicle. It's got to be 26,001 pounds, I think, for it to qualify. Or operating a vehicle that's not a commercial motor vehicle is defined in the statute in conformance with state traffic laws on public roads or rights of way or the owner's parcel. So all of this basically means here's some more stuff you can no longer enforce. Again, all of it, in my opinion, is unconstitutional. And I would suggest that you run it by counsel before you unilaterally decide, we're not going to do this anymore. If your counsel doesn't bother to mention that it's unconstitutional and give you the option of whether to do this, follow this statute or not, you might be working with the wrong attorney who's not willing to get a little bit creative. You might want to reach out to some other options of attorneys in the industry. Contractor restrictions, another terrible law. Okay, you can't prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker because that person isn't on a preferred vendor list. I'm okay with that. But you also can't prohibit them because they don't have a license. So the legislator is allowing unlicensed contractors into my community now as a matter of law, and allowing them to work in my community as a matter of law. Huh? So again, doesn't make sense to me. This one, I don't really know that it's a constitutional issue, but I'd be happy to talk about it with anyone that is looking into this a little deeper. And now we move on to budgets. Now, I was telling the guys earlier, I used to have about 25 pages of notes to do this presentation, and now I run it from a PDF. This one was about 2 pages of those notes, right here, this spot, this budgets and reserves. I've whittled it down to about 3 sentences, okay? When it comes to creating your budget, you do not have the right to artificially deflate the numbers. You have to tell your members what it really is going to take to operate and maintain your community over the course of the next year. You don't have a right to back into the budget towards the end of the year and say, well, this work is really necessary, but we didn't budget for it, so we're not going to do it. You have an obligation to do what is really required to properly and fully operate and maintain the community in the way that the governing documents require. Okay? Let the members argue and propose an alternative budget. You comply with your fiduciary duty that we mentioned earlier to actually propose a budget that meets the needs of the association. When you are talking about getting work done and you don't want an assessment or a special assessment, keep in mind, the longer you delay that work, the more it will cost. Okay, this was a condo example, but my old firm had one of the biggest special assessments in Florida up until all of this structural integrity reserve study business that came about a couple years ago in condos. It was $100,000+ special assessment against each unit. And the reason was that the balconies were failing. The association didn't want to get the work done because they didn't want to charge the owners for it. They thought they'd get voted off the board. So they waited. Vendor comes back, says, listen, I can see this is a problem and it's getting worse and worse. So this originally would have cost about 110 grand. By the way, that's about what the owners ended up paying each instead of the entire community. Well, now it's going to be $1 million. This is 2 years after the initial problem. eventually, again, it ended up being about a $10 million project that could have been done for less than 200,000. So the bottom line is if the work needs to be done, just do it. I know you don't want to increase your assessments. I know you want to be able to say we kept it low, but the reality is if you sit there, for example, I have a lot of clients that say we just don't have the budget to enforce our covenants against an owner who's violating the covenants. You don't have the budget. Okay, but you still need to do it. So figure out where to get the money. Now, one thing that you might consider is an amendment to your declaration that actually makes all those fees and costs that you're worried about spending and never getting back, it makes them an assessment against the lot that was responsible for it. So that if they don't pay, they get foreclosed. It can't be wiped out in bankruptcy once it becomes an assessment, unless you are undervalued or underwater. Okay. So there are things we can do to work around that, but don't just unilaterally decide this thing needs to be done, but we're just not going to do it because we don't want to charge our members for it. If the governing documents say you're supposed to do it, you have a legal obligation to take care of the community. All right, off my soapbox again. Okay, figuring out the budget, use last year's actual expenses and what you expect to increase. Hopefully, you're actually going out and getting estimates for some of this stuff as well, but to figure out what it's actually going to cost. The operating section of the budget is not limited to spending. If you had 50,000 in legal and I was able to get you those assessments back because we amended that declaration and you collected the money because people didn't want to lose their homes because they're not maintaining their property. If that's the way it worked, now you've got some extra money. That doesn't mean that money has to be spent on your legal budget. Okay. It just means that you have operating funds to spend on any appropriate association expense. So that's why I say don't back into the budget. Operating expenses identify the categories of income and expenses. Those are your line items for the day-to-day operation of the community. They need to be listed by account and classification. They should project the total proposed annual expenditure in each classification. Okay, we've got some of the things that might be included here. If you don't have these expenses, I don't know how, but congratulations. Then we've got reserves. Understand that in an HOA, reserves do not exist in the statutes. So when you talk about statutory reserves, you don't have them. Condos have them, co-ops have them. HOAs do not. The only way that a reserve is created in an HOA is if it's in the declaration, the developer created it by an actual vote that you have on record of the developer, meeting minutes, resolution, something to support it. Not just we created this line item in the budget, or the members actually voted and you've got a record of that. Majority of all members. Okay, if you don't have one of those things, you don't have reserves. You have operating expenses and operating funds that you've been siloing elsewhere. Okay, you might have tax implications from keeping that money that isn't a true reserve. So understand, I often come across, oh yeah, our reserve, we can't use these funds for anything other than X. And my response most of the time is, well, do you have documentation? It's not in your declaration. I looked. Do you have documentation to show that this reserve was ever created? And the response is, well, it's been in the budget since the community was created. That doesn't mean anything to me. So get a legal opinion from your attorney if you're not sure whether you have a reserve, but chances are in most communities that are HOAs under Chapter 720, you don't have a reserve. Now, here are just some definitions for, types of reserve expenses. It's basically money that you're spending on an asset whose useful life is more than a year. It's a recurring expense that's not going to happen frequently. Like I said, membership creating reserves. Calculating them, you basically take however, and this is a straight line method, but you take the estimated useful life of that item, you divide by the dollar figure that it's going to cost to do the next repair or replacement, and that's your reserve for each year. You can adjust that for inflation. You can have a reserve study done to figure out, okay, every 3 to 5 years, what do we need to shift because of the increased or decreased would be great, but because of the different cost of materials, labor, etc., what is it really going to cost? So if you've got just as an example, you've got a roof, maintaining it is going to cost 100 grand, and it's supposed to be good for the next 10 years before you need that maintenance. Okay. Now you're putting away 10,000 a year. 100,000 divided by 10 years. Easy math. Okay. Let's say in year 5, you anticipate, well, you know what? We've been putting away 10 grand, but I've heard that roofs are skyrocketing in price. It's now again going to cost 100,000 in year 5 because you're already 5 years in. Hasn't changed the life expectancy of that asset. It's just changed the dollar figure. Well, that 100,000 divided by 5 years, now you're putting 20 grand in for the next 5 so that you have the amount you need at the end. Now, a pooled reserve is a little bit different. It's basically, we're going to put away what we think we'll need for the next set of items to fail. Not everything. All right, moving forward, changing, you can use reserves for other purposes. That requires a member vote of a majority of the members at a meeting where a quorum is present. Pooling reserves you can do. Individual versus pooled accounts, I explained the difference. The straight line, generally speaking, you're going to put away more money, but you're going to have that money available for each asset. The pooled reserve, yes, you're going to have a reserve schedule, but it might be a little bit more or less every year, depending on what's going to come up. You can vote to partially fund or waive the reserves. Again, majority vote of the members. Terminating reserves is also an option. Majority of the total voting interests, not just a majority of the people that show up at a meeting where a quorum is present. Notice and adoption of the budget. Okay, the governing documents need to be reviewed. Your governing documents may say that you need to give 30 days notice of the budget and a copy goes to everyone. If not, if they don't say anything about how you give this notice, technically you need to give 48 hours notice posted regarding the budget meeting. Now, before it's adopted, I'd suggest sending it to all members prior to adopting so that anyone that wants to object has the right to do so in advance. But unless the governing documents require otherwise, you can choose to provide a copy at the meeting itself. After the budget's adopted, the association must provide each member with a copy or written notice, again, that's a postcard, that a copy of the budget's available upon request at no charge. If requested, a copy must be provided to the member. This is a records inspection request. Okay. By January 2025, January 1st, actually 2025. So hopefully you're doing this. You need to also put the budget on the website. Assessments and foreclosures is another topic we have a whole class about. And since we are now at 12:20, I'm going to skip ahead a bunch. We talked about special assessments and how those are adopted. The important thing that I'll add, that meeting notice needs to specifically state that special assessments are being considered at that meeting. Okay, and what the purpose of the assessment is and the proposed amount. That goes on the notice, the agenda, and obviously in the meeting minutes. The other thing that's different for special assessments and a lot of other things, it requires a notice being sent to the members after it's adopted, saying what the amount is, what it's for, and when it's due. Okay, I'm not going to go through the requirement to provide an accounting, but if someone asks what they owe for any amounts, you have to provide that to them. If it's a fine or other charge that isn't an assessment they owe, that gets wiped out if you don't comply with the 15 business day time frame. Collection of assessments, again, we have a separate class on this, and unfortunately, we just don't have time to go through everything today, but this is basically the content of that. You've got your financial reporting, and frankly, if you have a CPA, they should be giving you guidance on this. If you are with a management firm, they should be giving you guidance on a lot of this, but not all of it. But understand once you get the report prepared, whether that's by the association or by a third party, whether that's a CPA or someone else, doesn't matter. No later than 120 days after the end of the fiscal year, the board needs to provide every member with a copy of the financial report or that postcard that says a copy is available at request. And this one is at no charge to the member, just like the budget. Now, your level of financial reporting, this is the mo money, mo problems paradigm. If you have less than 150 grand, you really just need a spreadsheet of what you brought in and what you spent. If you have 150 or more, but less than 300,000, you have a compiled financial statement. At least 300,000, but less than 500,000, a reviewed financial statement. And 500,000 or more is the big mamma jamma, the prepared audited financial statement. Each one of these, as you go down the list, is more specific, reviews more documents. Your audit is literally a review of every document the association has in its official records, financial or otherwise. Okay. It's also a higher level of promised accuracy as you go down this list. Now, keep in mind, I said 500,000 or more. The other thing to keep in mind is if you have 1,000 lots or more, you also need an audit, even if you only have 150,000 in business. Now, if you have 1,000 lots and you're only generating 150,000 in revenue, I don't know what amenities or what services you're actually even able to provide to the members for that. So hopefully this isn't some crazy thing for you, but bottom line, the level of financial reporting is based mostly on the dollars that you generate. You can vote to raise the reporting level, reduce the reporting level, but that only applies for that fiscal year, and it might apply to the following fiscal year. That's by a majority of the total voting interests. So understand this is not a majority of just the quorum, it's a majority of all of the votes. Same thing with lowering, it's a majority of the voting interests present in this case. Okay, but you can do either or. You have disclosures that need to go in your financial reports. Whoever's preparing them should include this. And it basically says we don't have reserves. We might end up with a special assessment if something goes wrong. That's what both of these basically say. Moving on to contracts and bids. Contracts need to be in writing. This is the statute of frauds in Florida. If it can't be performed within a year for the purchase or lease of materials or equipment, or if it's for services. Now, my opinion is all contracts should be in writing. They should be in contract form. When you get your estimate from your vendor and it's a one-page document for a $500,000 job, please, for the love of God, send that to your attorney to put together a real construction contract. Even if it's painting, I don't care if it's your landscape vendor, I don't care if it's your trash collection. Every single contract that the association has should be run by the attorney, and they should be giving you an opinion on how dangerous that contract is for you. Sorry, Mike, close your ears, but even your management contract should be reviewed by an attorney to make sure that you are protected. Now, fortunately, Empire doesn't have anything egregious in their contract, but the reality is that you should know what you're signing. And if you're not a lawyer who's been practicing contract law for years and years, you really should have that reviewed. Most of the time, I'd say 90% of the time, there are several or many crucial provisions that are simply not included. I don't know how we jump back all the way there, but let's go down around here. All right, let's jump back to where we were. Okay. So again, have your attorney review all contracts. Bidding, if the cost is more than 10% of the total annual budget for any item that you're going to have done in your community or anything you're going to buy in your community, including reserves in that 10%, the association needs to get competitive bids. You don't have to take the lowest bid. You don't have to get bids if there's an emergency that you need to address. So for example, we had a hurricane, the roof blew off the clubhouse, we got to get it fixed. We know John's a roofer. We're going to reach out to him. Okay. Don't have to get bids. You just got to get it done. Now, if there's no one else in the county that does this work, you don't have to pay someone more to travel to you. Contracts executed before October 1st of 2004 and any renewals aren't subject to competitive bids. And there's a whole list of contracts that you don't have to get bids for. Attorneys, accountants, architects, managers, okay, engineers, landscape architects, or employees. All of these need to be in writing. That's why if you're asking me for any kind of guidance, I'm asking for a representation agreement before, because that contract needs to be in writing. Okay? But these are the categories that you don't need bids for. So when your manager tells you you should get 3 bids for X, look at this list, see if you need them. If you know a vendor and you really like them and your entire board wants to work with them and they're on this list, you don't need bids. Estoppel certificates are included in collections, so I'm going to kind of skip through because we're already close to the 2 hour mark. But it's basically a document that you need to send out anytime that someone's working on a sale or mortgage of a lot and they want to know what it's going to take to get back to square one with the association. That's what an estoppel certificate is. That should generally be filled out by your manager. If your attorney is going to get involved in collection of unpaid assessments, or you're working on covenant enforcement, understand that anything that's not listed here, including those attorney's fees and costs that the attorney has spent, that does not take care, I'm sorry, that isn't listed, is not going to be covered and is not something that this person that buys in is going to have to do anything about after they buy in. Estoppel is basically it's a separate concept from waiver, but it's very similar. It's basically if you don't take care of your own business and you don't tell me this is a potential problem, I don't have to do anything about it. There are statutory fees that you can charge for these, and it's effective for 30 days. I don't know anyone that mails these for 35 days if you do. The fees can be increased based on whether there's a delinquency, whether they request it on a rush basis when they're trying to get this closing today and no one told you about it before. Okay. But understand the big thing is you don't get your fees back if you don't provide it within 10 business days. You don't get a rush fee if you don't provide it within 72 hours of the rush request. Pardon me, and you don't get to charge the fees for it if you don't provide it within the right amount of time. Covenant enforcement, another class that we have. This is for HOA credit when we teach it. And it's basically go through, enforce everything in a uniform manner, do it timely. This is policy number 7 or 8. Okay. Make sure that you are doing things the right way and automating as much of this process as possible so that you're not sitting there having to have a board meeting every time someone's in violation and you want to send it to counsel, or management needs to send out the next of the standard 2-3 letters that management will usually send out advising the owner that they need to cure this violation. Okay, the big thing is let owners know what you're going to do when they violate and then do it. Okay, so it's timely, uniform, and consistent. Those are the 3 things that you need to do with everything in your community in order to avoid, like I said, selective enforcement and other defenses. Okay, fines, I think, are a waste of time. I think they're a waste of your money because all they do is slap someone on the wrist and say, don't do that. They say you owe me money that I'm never going to actually do anything to collect because I've never seen a community, except literally once in my career, actually file a lawsuit to collect fines. The only time I saw that actually happen in practice, it was because they were allowed to collect the fines as an assessment according to their declaration, and they were already collecting other assessments from those owners. Okay, that's literally, I've seen 2 lots, 1 community, 1 time at the same time.
Hey, Alan, just a quick thing. I lost power, just came back in, and when I came back in, none of the questions in the Q&A, I can't see them anymore. So I'm going to have to rely on you for that later on.
We'll take care of it. No problem, Jeff.
Okay. All right. I'm going to put the link for the evaluation in the chat now because they are doing work outside. So just in case it happens again, folks, I'm going to place the link in the chat in just a moment. But that doesn't mean you can leave now. The required part is after Alan finishes the final slide, then you fill out the evaluation. Then you can choose whether you want to stay on for the Q&A or not, or take off. Okay. So Alan, back to you.
Sure. And just so everyone's aware, we're almost there. We've got 13 more slides, and I think one of them is just telling everyone what class they just took. So we're almost there, guys. But again, fines, there is a procedure that needs to be followed. It includes the board voting, then a 14-day written notice that a fining committee is going to meet and have a hearing. They take evidence, they decide whether to levy the fine. The problem with that is that most communities, in my experience, can't actually get 3 people to serve on that fining committee because they can't be directors, officers, managers, or any of their family members. And let's be realistic, the fining committee is not the most beloved entity or group within your community. Okay, they are the ones that are telling people you owe the association some money that no one else owes. All right, now suspensions, same deal. If that suspension is for non-payment, the board gets to decide. If it's for anything other than non-payment, it is basically a 14-day notice, committee hearing, then notice to the owner. And I know I'm breezing through this because, like I said, we do have a separate class on it. And since you need 4 credits anyway by the end of your 1 year of being on the board, I would recommend that you just go ahead and take these classes. And those are kind of the biggies that I mentioned, the top 4 that I think will get you the most basic and useful knowledge is covenant enforcement, collection, and a couple others. Fines can't exceed $100 per violation, or $1,000 total for any ongoing violation. If it's not ongoing, it's just something that happened once, it's no more than $100 per violation unless the governing documents say otherwise. Now, keep in mind, I mentioned leaning for fines, assessments as fines, or fines as assessments. You can't do that until that fine hits $1,000 or more. So unless that violation is ongoing for at least 10 days, you're not going to be allowed to you're not going to be able to lien for it. Okay, you can suspend use rights as well. That can be a valuable tool. You do the same process as fining for use right suspensions or voting suspensions, which are subject to some case law and probably should be supported in the governing documents if you're going to do it at all. Keep in mind, if you suspend the right to use certain aspects of the community, that suspension can't prevent the owner from actually getting in and out of the community, parking where they're allowed to park, getting into their lot, but it can, and this is something that changed over the last 10 years or so, judges finally understand if you require them to show ID and turn off their key fobs to get through your gate, that is not suspending the access to the property. It's suspending one method of access. So judges are understanding a little bit more now. Hey, you know what? This is actually a good practice. It's okay. And I will tell you, the properties that are rented, or the properties where the spouse wasn't telling the other spouse that this was all going on, that the violation was there, that the threat of suspension was out there. As soon as you have the other spouse who wasn't involved in the situation that now has to show their ID at the gate, I'd give it less than a week before that violation gets cured. So this one can be very useful. And same thing, if it's based on a delinquency, I give it about a week before that delinquency gets paid or the owner reaches out for a payment plan. Let's see, use right suspensions we talked about, voting suspensions I mentioned. We've got pre-suit mediation. This is the first thing you need to do before you go forward to court on any covenant violation. The procedure is basically you send out a letter, it's a 20-day letter, and it gives the owner the opportunity to respond and say, yes, I'll go and meet with you as the association, whether it's with counsel or with management. It's got to be at least one director, in my opinion, that has the authority to settle. And I'm actually putting together a mediation class as well. But bottom line, you sit down, you try and figure this out, and you've got someone that's not biased in the room to kind of go back and forth and try and figure out a creative solution to get this issue resolved. A lot of these are very straightforward. You cure the violation and we're done, but that's not always the way that the owners look at it. So mediation, we've got prevailing party attorney's fees. Now, attorney's fees are only awarded if they're authorized by contract or statute. The good news is for covenant violations, it's authorized in almost every declaration I've ever looked at, and it's authorized in statute even if it's not. But if you don't send that offer for pre-suit mediation, you don't recover the association's attorney's fees and costs. If the person that it was sent to doesn't respond, they don't recover their attorney's fees and costs, regardless of who wins. We talk about self-help. This is when you go onto someone's property and cure a violation for them. It's not a good idea, but judges are now saying, and the courts have said, that it is legally required. There's one case in one DCA that says you don't have to do this anymore as of, I think, 3 weeks ago. Most courts are going to say that you do have to do it if you've got this right in your declaration. So if you've got the right to go onto someone's property, then before you try and get an injunction against them to cure that violation, you go to court and say, Judge, I want you to tell this person they need to fix this problem. You have to try and fix it for them by going onto their property and curing it. Again, this is only if your declaration allows for self-help. I think it's a dangerous game to play going onto someone's property. We're in Florida. Certain areas of Florida may be more dangerous, but anywhere in Florida, you've got stand your ground laws. You've got guns in many, many homes, and you've got people that don't have a problem blowing a hole in their own door when someone comes a knocking. So the bottom line is, you do not want to be on that person's roof with the ladder hanging off when they come home and they throw that ladder on the ground and now you got to jump or pray that they don't come back at you. So self-help, I think, is not a great idea unless it's really innocuous work being done, which is, mowing the lawn, maybe, um, cleaning up the sides of the driveway, clearing out the crack weeds, we call them, basically weeds that are inside the cracks, clearing out the apron, things like that. But there's danger in all of it, there's risk in all of it. So my suggestion is if you can remove it from your declaration by an amendment, that's probably the better course of action. And that's all we've got. So I appreciate everyone coming today. We'll get into the Q&A in just a second.
Alan, what do you see in the Q&A? Some good ones there?
Yeah, there are a couple. So let's go through them. Mary is asking, what's an example of what relies on, well, she says condo docs. Hopefully she's not in a condo. And what applies to state statute? Honestly, that is a legal analysis on a case-by-case basis of what's going to apply in which situation. But again, going back to that Kaufman language I mentioned, if you don't have that language in your declaration, anything that's procedural in nature that the legislature changes is going to apply across the board regardless of what's in your governing documents. Anything substantive in nature that was already in your documents, if you don't have that language, you're basically going to say, well, you know what, legislature, you don't have the right to override what my governing documents have said for X amount of time. Now, keep in mind, this is amendments to the statute. Okay, if your declaration was recorded just this year, or you amended a particular provision just this year, you can't amend around the statutes that already existed. So this is where you've had this provision for a while, and the legislature says now if you have it, it's unenforceable. All right. And again, I know that might sound convoluted. That's because it is. Okay, Jennifer asks if you're a board member that didn't have 4 hours of continuing education by June 30th, 2025, is what you still voted on okay, even though you should have been suspended? Yes. Because like I said, if you are supposed to be suspended, the reality is that it doesn't matter unless someone actually caught it before you took the class. So if no one noticed that you didn't do this, those credits and those votes still count. All right, Paulina asks, do HOA board members need to actually reside at the property or just need to be owners? That's one that you need to look at your bylaws and specifically the section that designates who's authorized to serve on the board. Generally speaking, Chapter 720 says anyone that's an owner is eligible to serve. That doesn't mean that's the only list of people that can serve. Paulina asks, is a budget workshop considered a meeting? Well, a board meeting is any time, and a budget meeting is any time that a quorum of directors meets and discusses association business. So there's no such thing as a workshop under Florida law. It's either a meeting or it's not. And if you have a quorum of the directors that are putting together the budget, my perspective is you've got a meeting. Paulina is very busy with questions. I appreciate it. Do HOAs have the same requirement as condos to include all proposals and contracts? Yes, those need to be on the HOA website. I mentioned that earlier, at least 48 hours in advance. And that's how you're generally going to provide them to the members, is through the website. The election rules and procedures, Paulina again, discussed here are the statutory ones, right? But our HOAs can have different rules. Yeah, I think, pretty clear on the fact that in reality, it's not going to be a situation where you look closely at the statutes. It's almost all going to be governed. Your election process is almost all going to be governed by your bylaws. There are statutes that pertain to that, but understand it's almost all going to be based on what's in your bylaws. Is building paint color code, and again, this is Paulina, is building paint color code considered confidential or is it subject to member inspection? I don't even know what part of that could possibly be confidential. So I don't know. I mean, if you're talking about the colors that you're using for someone's architectural application, that's generally going to be part of what the members are entitled to inspect. We've got someone else here, Donna. We only need to keep all records for 7 years, including tax records. Anything older can be shredded, almost anything. There are some records that you don't yet, but you'll need to keep from inception, which is the turnover records. And I'm saying this based on what condos are now required to do. So I suspect in the future that the legislature is going to change this so that everyone needs to do it. But those are the documents that are turned over at turnover within 90 days after turnover, copies of your governing documents, rules and regulations, and all amendments to those. There's nothing that I can think of offhand that's more than 7 years.
Folks, remember to put all course-related questions in the Q&A module, not in the chat module. Chat module is for technical questions about the evaluation, something non-attorney related for me or for Mike.
Michael asks, is the association required to provide the roster of members at the request of an owner? That is something that, yes, is subject to an inspection upon request in writing. Paulina, assuming electronic voting is available, but not all owners sign up, wouldn't putting out ballots and ballot boxes to allow for voting or putting them away early constitute a first-degree misdemeanor? No. I mean, you do need to allow for voting in another method. Putting them away early would be a problem with the election process, whether that's a misdemeanor because it's election tampering or something similar. I can't say automatically based on your description that it would be a problem. It would be a problem with the process unless you have actually announced that the balloting is closed. Jacqueline asks, where can this information, such as copying records and fees? 90% of what we've gone through today is in Chapter 720 of the Florida statutes. The administrative code covers some, but not much of what we've discussed. It really covers more condo issues than HOA. And some of it is case law. Gloria asks, can the declaration be updated when preserving? Not if you're, well, technically, yes. An amendment can be actually a preservation instrument now. I don't really love that concept, but it's an option. My suggestion would be to amend and then immediately preserve for all of the preserve your covenants after the amendment's done so that you get 30 years from a date that's shortly after the amendment passed. And you're including that amendment explicitly in the preservation instrument. Ralph asks, can a board member serve after 8 years? I think you're referring to the condo law, not the HOA law, that there is no HOA law that specifies the time frame that a director is allowed to serve, the maximum time frame. In a condo in, I think it was 2018, the statute changed to specifically say you can't serve more than 8 consecutive years, except for in certain circumstances in a condo. In an HOA, that law just doesn't exist. Hyrule asks, the remaining board members are permitted to appoint eligible candidates to fill the open positions. Correct statement. Linda, does this apply to RV units between homes, even though CC&Rs don't allow for trailer parking between the homes? I presume that's the vehicles being parked. Keep in mind, that's not your personal vehicle. I mean, I can see a crazy owner making the argument that's my personal vehicle, but generally speaking, I don't think an RV would be something that you can't enforce if it's located between homes. It's going to be visible for sure because it's large enough. I don't see that being something that gets around the statute. Nicholas asked, does that parking rule also apply to parking on the street? The answer depends whether or not your streets are actually owned and governed by the community. If you have municipal owned streets, you probably don't have much of a right to enforce anything on those streets. If they're owned by the association, then generally speaking, yeah, you can probably enforce, but keep in mind you're subject to the statutes. Paulina, so are you saying that HOAs can no longer prevent non-licensed handymen and workers from working on individual lots, but HOAs can still ask the owners or employees to sign a waiver? That is what I'm saying. And no, you can't require the waiver according to this statute that I mentioned earlier that says you can't require people to have any kind of license or, have conditions on the ability of a vendor to come work in your community. Art asks, I'm having a special meeting soon where we, the board, are reviewing and approving the 2026 budget. Members can ask questions, but can we modify the proposed budget in real time during the meeting and approve? Yes, but keep in mind you would want to send the approved budget out and notice that the approved budget is available after that meeting for sure. Guillermo, can you please explain, is there any change which allows a pause for 2 years in the collection of reserves? That is a condo issue. You do not have statutory reserves, like I said, in an HOA at all. So if you've got reserves, it's not allowing a pause. Your members just vote to waive the reserves for those 2 years. Paulina, can HOAs or their attorneys legally charge for estoppel letters requested by unit buyers? Yes, as I mentioned, there are specific charges. They're in the slides that you'll get later, but they're also statutory. Linda asks, can the association do the work that needs to be done if the homeowner doesn't and then bill the homeowner in lieu of a fine? Only if your governing documents actually allow for that. David asks, and Mike, you'll have to answer this one. Is Empire hiring CAMs right now?
We are always looking for good cans, so go to our website and you can apply there.
There you go. Dawn asks, the 8 hours per year of required training, is that calendar year? If I'm newly elected, do I need to do another 8 years before December 31st? This is from the date you were elected. So you've got, if you were just elected, let's say in late October, my perspective, because the statute's not 100% clear on this, is that you've got until October of next year to get that extra 8 hours. Cheryl, board vacancy appointments is the entire question. The answer is yes. If there's a vacancy, you can appoint them. I think that answers the question, but I'm not sure. Randy asks, how are architectural requests approved or denied when an architectural committee no longer exists? Does everyone resign? Well, the board should be appointing new directors or new members to that architectural review committee. Sometimes, even though it's the wrong way to do it, the board will just vote on those. I don't like that option. I don't know really what a better way would be, because the bylaws and the governing documents generally don't say what happens in that instance. They say there shall be an ARC or an ARB or an ACB or whatever you call it in your community, and those are the people that get to decide this. So my perspective is the board needs to find 3 more people willing to sit in those roles and compose that committee. Cheryl, how do you confirm board members are current with certifications? The certificate should be in the official records, as I said right at the beginning. If it's not there, they're not current, period, whether they took the class or not. Paul, thank you for your nice comments. Jackie, is there a time frame limitation for collecting dues? 5-year statute of limitations. Now, where that starts is kind of up in the air under Florida case law. It's 5 years from the date of any assessment. It's not clear whether you need to start over or have a new collection process, because it's technically 5 years from the date of the assessment to the date of the complaint being filed. But it could be 5 years from the date you record a lien, 5 years from the date you comply with the last step in the pre-suit process, which is after recording a lien. So that's when you'll want to talk to your attorney about their personal opinion on how that works. Evan, thank you for the kind words. Regarding personal litigation, we operate as a fiduciary and the board votes on everything. Are there protections from personal civil suits? Yes, members can sue individual directors. Hopefully you've got directors and officers liability insurance. That is step one. I wouldn't serve on a board if my community doesn't have that. The other thing you might have in your governing documents is actual indemnification, meaning the association pays for your defense unless you actually committed a crime that caused that lawsuit to be filed. Tony, is there a requirement for an HOA to have a website? If you have 100 lots or more, the answer is yes. How can an HOA establish and pay for a website for the community? That goes into your budget. Or like I said, if you've got a management firm that provides a portal, that's your website. What documents can be included on the website? I went in over that way before you asked the question. So hopefully you'll get the slides today and you can take a look at those. If not, it's right in the statute, which is where we get the slides from. Donna, if the streets in our neighborhood are county owned, can the HOA tell a property owner they can't park a semi on the street? No, but you can call the county and have them tow that semi. Cheryl, do you have to allow discussion from members on agenda items during a board meeting? Can discussion be held at the end? The answers are yes and yes. Now, keep in mind, if you allow that discussion at the end, you're explicitly telling the members, we don't care what your opinion is. We're just allowing you to talk about this because we have to from a legal perspective. So you're indicating to them that their input doesn't mean anything. The members probably won't love that, but it is not legally prohibited. Nicholas, if a home gets taken over by a bank, does the bank assume the responsibilities of the old homeowner in terms of paying fees? That's in our collection class. And the short answer is they'll take over the obligation for maybe some of the assessments. They're definitely not going to be responsible for the interest, late fees, attorney's fees, and costs that were incurred against that previous homeowner that generally gets wiped out whenever a lender forecloses. We are 5 minutes from close. I answered every question that's in the Q&A. I want to say thank you. I do have a 1 o'clock meeting, but I want to say thank you so much to Mike and to Empire for having us. I don't know how I'm going to survive this meeting and continue speaking, but that's not your problem, it's mine. So thank you all. Thank you for the kind words in the chat. Thank you for the kind words in the Q&A. Thanks to Mike and Empire for having us as always. We love working with you guys, and not to be biased, but you especially, Mike, are always a pleasure. And Jeff, you're
Absolutely.
always okay to deal with.
Yeah, sort of, kind of,
Thank you
depends on
both
on the
very
moon
much.
phase.
All right. Well, that was a lot of words. I hope you all got a lot out of it. If you need to reach me, you can shoot me an email at as@kbrlegal.com. That'll be in the email that goes out to everyone after the class is over. If you'd like some helpful hints that I put on LinkedIn, feel free to follow me there. I usually once or twice or 82 times a week, depending on my mood, will share a couple, comments about how to be a better manager, how to be a better attorney, and how to be a better board member, or just in general, tech tips and things like that. So feel free to follow. But when it comes to legal advice, you're not getting it on LinkedIn. Feel free to shoot me an email.
Sounds wonderful. And technically, you're not getting it with these classes either. This is
Correct.
educational in nature only. So please don't go to a board meeting tonight and say, Alan and Mike said this during the class, and this is how it's got to be. Always contact your association counsel if you're unsure about something or if something is not clear.
And I see just a quick question that where am I located? I'm in Winter Springs. I'm in the Central Florida office, but our firm practices statewide. I know Empire pretty much does as well. So anywhere that you're located within Florida, anywhere your community is located, if I'm not physically there, that's what these Zoom meetings are for.
Excellent. Well, thank you both. Alan, you have your appointment. Mike, you're welcome
Yeah.
to hang out. Mike, this is your event, but I'm going to hang out and go over the evaluation process for anybody still struggling. So, Mike, before I do that, Alan, you take care. Go do your
Thanks,
thing.
everyone.
Thank you. And Mike, if there's anything you'd like to mention before I share the screen and show those who might be a little tech challenged, have at it.
I would just like to say to everyone, thank you for spending the last few hours with us here. It's much appreciated. If there's anything Empire can do for you and your association, please don't hesitate to reach out to us. The best way to contact us is to go to our website, contact us from there. Our phone numbers are there, our addresses, stop by the office. We're always happy to speak with anyone.